And my name is Machio. I'm the Vice Chair, and welcome.
Good afternoon. I'm Olu and Evelyn. You're welcome. Afternoon, Council. Jacqueline Ngutia, you're welcome.
Council, my name is Justice Mohammed Ibrahim, Commissioner and Judge of the Supreme Court. Karibu sana.
Good afternoon, Wakili. My name is Fatuma Sichale, Commissioner. Karibu sana.
Good afternoon, Council. My name is it good afternoon? Yeah, good afternoon. My name is Charity Kisotu, a Commissioner. You're welcome.
Thank you.
Yes, good morning. My name is Isaac Ruto, member of the Judicial Service Commission.
Good afternoon, Council. I'm Zilani Caroline, Commissioner. Karibu sana.
Good afternoon. My name is David Majanja, Judge of the High Court and Commissioner, and you're welcome.
Thank you very much, Commissioners, for that introduction. Madam Machio, we are going to engage you on the application you made for the position of the Judge of the High Court. But before we delve deep into the interview, please confirm your county and your ethnicity.
The county is Kakamega. My ethnicity is Luya. My subtribe is Wanga.
Thank you very much. Commissioner Macharia will take it from here.
Okay, very quickly, I'm looking at your CV. You've mainly been a private practice, which is all right, but you need to demonstrate to the Honorable Commission the impact you've had in private practice that makes you suitable. And in answering that question, please don't relate to the many years that you've practiced, the cases you've done, because generally that is what is expected of every other professional, especially if you're in private practice, but where you think you've made high impact that demonstrates your suitability and the fact that you're distinguished and that you're ready to be a judge.
For the 22 years I've been in practice, I believe I've contributed to the jurisprudence of this country because of the many cases I've handled. I've handled so many cases. Luckily enough, the law firms I worked for were dealing with several aspects of law. So I've managed to touch at least one of those cases and completed them within the shortest time possible. In my practice, my policy has always been to be ready to proceed, and that's what has made me complete several matters at a go.
But you see, that is all right, and we appreciate that. But I was very specific to the fact that, unless you're able to show the impact and, and you demonstrate that with an example where you think that you went, beyond the ordinary, it becomes difficult for the Commission to consider you in comparison with the others who are able to demonstrate, with very specific examples of the achievements in the legal profession.
Okay, number one, I'm a hard worker, and I'm diligent, and it is true that I've managed to be where I am. I've always taken my work seriously, and honesty is what has made me to be different in terms of my career, and that is what I've calculated, and that is what has helped me to build my career: honesty and hard work.
Okay, fair enough. Thank you.
Thank you, Justice.
Thank you very much, Honorable Chair. Wakili, I will ask you one or two questions just to test your technical competence.
Yes.
What is a cognizable offense?
I'm sorry, maybe you can break it down for me.
We talk of cognizable offenses and non-cognizable offenses.
I'm sorry, maybe I'm not able to answer that for the time being because not practicing criminal for quite a while.
All right, that's
Yes.
understood. Now, is a CCTV footage admissible in evidence in a criminal trial?
Yes, it's part of electronic evidence. It can be used under Section 106B of the Evidence Act.
What do you require to accompany it for it to be admissible?
Certificate of electronic evidence. You have to show how you extracted the CCTV footage to the instrument that you'll be using, either flash disk or...
Thank you very much.
CD.
That's the correct answer, and I'm satisfied. That's all from me. Thank you, Chair.
Thank you. We'll continue with that line of discussion. Madam Machio, tell us, what are the overarching objectives of the Victims Protection Act?
The objectives of the Victim Protection Act were mainly to protect the victim because of the sensitivity of what they've undergone, and also about the trauma they've undergone as victims of crime.
Mm-hmm. So when you are successful in this bid and you are now sitting in the criminal bench, how are you going to make sure you protect the victims?
Under the Act, I know under the Criminal Procedure Act, there are various ways you can protect the victim. First is to allow them to participate during plea taking. When they're applying for bond, they can be allowed to participate. And also, when they are doing plea agreements, you can protect them by also allowing them to participate. Another factor,
it's okay,
it's not coming to my mind at the moment.
Yes, the most critical one is when you are sentencing.
Yes.
Another question is the place of precedence.
Yes.
In our legal regime, or what we call the stare decisis.
Yes.
Please locate it in the Constitution and tell us the importance of precedents.
Precedents, number one, they help us create jurisprudence. They help us know the decisions that have already been made. What has been the law that has been used in making the decisions. Precedents also help us in terms of assisting as in interpretation of the Constitution and also on the law. What have been the decided cases? How have the judges been using these precedents to determine a certain aspect of law?
Can you be able to locate it in our Constitution? The place of precedence in our Constitution?
In judicial review?
No, precedents generally.
Generally?
Yes. Where have they been placed in our Constitution? It's okay, we can pass that. Justice Majanja.
Good afternoon.
Good afternoon, Your Lordship.
Under Article 259,
yes,
the states that the Constitution shall be construed according to the doctrine of interpretation that the law is always speaking.
yes.
What does that mean?
I believe Article 259 was intended to, so long as it protects the values
yes, but
and
it says
principles.
that the Constitution shall be construed according to the doctrine of interpretation that the law is always speaking. What does that mean, or what do you understand? Yes, that the Constitution, Article 259 states that the Constitution shall be construed according to the doctrine of interpretation that the law is always speaking.
To me, the way I understand it, it means that the society keeps on changing. Issues in the society keep on changing. So we have to interpret it according to the changed circumstances
Okay.
of the needs of the people.
Okay, you will have a look at that. And finally, from me, there are those who say judicial restraint is a good thing. Why do you think it's a good thing?
To me, it's important. Judicial restraint, it's important when the law is very clear, the law is very direct. That is when you can use judicial restraint. There is no ambiguity in the interpretation.
What is the opposite of that?
There is a judicial activism.
Mm-hmm.
Judicial activism, you use your integrity, you try to be creative. And this happens especially where you are declaring a particular statute or particular statute, it's unconstitutional. That is where it happens for judicial.
So are you saying that if you exercise judicial restraint, you can never declare a statute unconstitutional?
You can.
Okay,
You can.
Under what circumstances?
For example, if it's discriminatory, especially if it infringes the rights,
Okay.
and it's discriminatory.
Okay, we leave it at that. Thank you
Yes.
very much for your time.
Thank you, Honorable CJ. Council, I have had a chance to read your sample writings,
Yes,
which I find quite thorough
yes.
and well researched.
Thank you.
But you have never sat in any body where you have decided cases in a tribunal?
No,
Okay.
unfortunately, I've been defending
Okay. Okay.
my clients, but I'm always in court most of the
Okay.
time. Yes.
There is a matter, your sample writing number 1.
Yes.
Oh, sorry. Sorry, no, I'm mixing up. Here it is. Yes, number 2. It is a matter where it was a suit. It was not a court case, but it appears you had submitted a matter in court under the Married Women's Property Act.
Yes.
In the High Court in the year 2012.
Yes.
And you're acting for the husband.
Yes.
And the other person is the spouse, the wife,
Yes.
who they had already divorced, and now it was a question of division of property.
Yes.
Yes. I want to know, how did it go? Because you argued this case before the Mary Nyambura case decision.
Yes.
You know the Mary Nyambura decision
Yes.
in the Supreme Court?
Yes.
By the time you were doing this case, it was well before. It was 2017, I think, 2012, much earlier.
Yes.
So how did it go?
My client was given a bit of the property. I think it was around 50. By the time we were, the judgment was being delivered, he was given 50.
50-50.
Which was to be offset. Not 50. They divided 50 between the two. Then the children were given 25%.
Oh, it was by consent?
No.
Oh.
That is how the court decided.
Okay.
I've remembered the children were given 25% each, and the husband and wife
Okay. Now, to go to
were
the main
given
issue.
50%, yes.
Subsequently, Mary Nyambura Kangara case came versus Paul Ogari regarding division of property between parties who are not necessarily in marriage.
Yes.
They could be cohabiting or having cohabited, and it's nothing to do basically with marriage. You know the principles in that case?
Yes.
What did it say?
For cohabitation, they need to have stayed for a long period of time.
No, I'm talking about the division of
In division,
the property, yeah.
or what the court said, they have to look at, even though there was no marriage, their relationship would not be termed as cohabitation, marriage by cohabitation. But the court recognized the fact that they acquired properties when they were staying together, and each party made a contribution.
Yeah.
So the court said, of course, the parties were entitled according to their contribution.
Okay. Now, then came Ogentoto decision.
Yes.
You're aware of it?
Yes.
What was the principle in Ogentoto?
Ogentoto, yes, it was about Article 45, where parties had gone under Article 45, claiming that they're entitled to sharing of the matrimonial property at 50-50.
What did the court decide?
So the court said Article 45 did not give proprietary rights to the parties.
It dealt with status.
Yes. It just deals with the status in the marriage, in the term that they are equal during the at the time of marriage, during the subsistence of marriage, and at the time of dissolution of marriage.
But in terms of property, what is the principle?
It has to be as per the party's contribution, either direct or indirect.
Yes. So if your case came up today, would the decision be different?
No. Luckily enough, the way I do my matters, even in division of matrimonial, even prior to that Supreme Court authority, my principles are usually three. First, I show whether the marriage has been dissolved. I go showing whether the properties were bought during the subsistence of marriage. And the last one, I show how the parties contributed, whether direct or indirectly. And I arrange my case in that manner. That's why you saw in this case I was able to get the percentage my client deserved.
Okay. Yes. Thank you. Lastly, just a matter of interest. I've seen that you have submitted opinions to courts in the UK saying that you are an expert.
Yes.
Are you an expert on Kenyan law?
On family law, yes.
Family law.
Yes.
Okay. And your depositions have been accepted by those courts?
Yes.
Okay.
Yes.
And they've been used?
Yes.
Okay.
Yes.
Okay, thank you. I wish you all the best.
Thank you.
Thank you, Chair. Good afternoon once again, Council.
Good afternoon.
I agree with Judge that you write very well, and I must commend you for that.
Thank you.
In most of our courts, you find people charged for obtaining by false pretense, especially in the context of land agreement gone sour.
Yes.
What are the three elements of the offense of obtaining by false pretense?
There must be the intention. There must be the intention.
Just procedure.
Of hoodwinking somebody that you're in a position to provide, maybe if it's goods, the goods. Secondly, there must be a collusion, if I'm not wrong. As I said, I'm not familiar with the criminal, but I'll try and remember what I was taught. There must be an intention to defraud.
Which you had mentioned as the first one. Yes. Okay, but at least you have put it, given as a rider that
that's what I can remember.
Okay, and can you also share with us two decisions of the High Court that are conflicting? Any that you're aware of? Family law, criminal law?
I'm trying to think about it. I think there was one at the Supreme Court. It was not conflicting, but they made different.
What matter? Maybe you could give.
I can't remember.
Okay, and at the High Court level, where you want to join?
No, I can't remember.
Okay, but you are aware that there are certain conflicting
yes.
decisions, sentencing, in sexual offences cases.
Yes, there's the issue of conflicting about marriage.
Okay. So if appointed as a judge, how are you going to vary the decision of courts of equal status or coordinate jurisdiction? What will you consider before you vary or disturb?
If you're in the same jurisdiction?
Yes.
If you're in the same jurisdiction, I'm bound by decisions of the higher court.
I'm asking
But
about
if
you.
I'm in the same jurisdiction, basically I'll apply the law.
But the other judge also applied the law.
Yes.
So
and
what
also
consideration would you?
The only thing maybe will vary is because maybe by then the law has changed.
Change of law, any
Change
other?
of law can cause variation. Another, I think, change of circumstances also. I think that's what I can remember.
Okay,
for
thank
now.
you. Thank
Yes.
you and all the best. Thank you, Chair.
Thank you, my lady. Good afternoon once again.
Good afternoon, Your Honor.
Now, Article 159, sub-Article 2 of the Constitution
Yes.
gives guidelines on how judicial authority should be exercised.
Yes.
One of those guidelines speaks to promoting ADR. What are the modes of ADR that you know of?
I know there's negotiation, there's conciliation, there's arbitration, and there's mediation.
Okay, could you differentiate for us the role that a conciliator plays in a conciliation as opposed to the role that a mediator plays in a mediation?
The difference in mediation, a mediator is a moderator. Her aim or his aim is to make sure the parties have reached a settlement. Now, the difference between a mediator and a conciliator participates in the proceedings. He can give even opinions, he or she can give opinions, can give even solutions to the parties. So it's upon the parties to decide on what is best, based on. The difference is that the conciliator participates in the proceedings.
They all participate.
Yes.
I just want to understand the nature of participation. You are right about the
Yes,
conciliator.
I'm saying in conciliator they give
Yes.
opinion.
What about the mediator?
Mediator ensures that the parties arrive at a certain settlement. Yes.
Okay, I'll take that and I wish you well. Thank you, my lady.
Thank you.
Thank you very much, Honorable Chair. Council, would you tell us how you will go about a situation where you are expected to make a decision, yet the law is, there's a lacuna in law?
Okay, maybe you can break it down for me.
I'm saying you are undertaking a matter.
Yes.
Of course, you're trying to look at the relevant, laws or legislations, and you find that there is a lacuna or there's no clarity in law. How do you go about making a decision if you become a judge and you find yourself in that scenario or in that situation?
When I find myself in that situation, maybe I can look at decided cases. Maybe they can guide me in that aspect. Also, through research, but I think the main thing what guides us is the Constitution.
Yeah.
I would want to think about
Okay. Okay. Thank you, Chair.
Thank you.
Good morning again.
Good afternoon.
Oh, it's afternoon.
Yes.
Sorry. Now I see you got you've practiced in your career for quite a bit of time, and I'm interested in knowing about your leadership capacity. And in your career, what can you describe as your key achievements as a leader? That is specific achievements that can be attributed to you as a leader and your leadership excellence.
As I said, I'm very hardworking. In my office, I'm also diligent. As soon as the instructions come, I've been able to complete within the timelines, and I've been able to execute, of course, with my team. Usually when a case comes, I allocate according to the nature of the case. I have a team, I have a student, a pupil. At the moment, I also have an associate. So we try as much as possible because of timelines and make sure that matters are completed within the shortest time possible. As we speak, most of my cases are complete. If they are not complete as we speak, they have dates already.
Any specific innovative technique that you may have come up with?
What I usually do, what I discovered during the end of the year, what I usually do, I take audit personally with all my staff of all my files in the law firm. I take audit of the file, and each case I'm doing, or the cases I have, I categorize them according to the, if it's civil, if it's children, if it's family, I categorize them. Once I've categorized them, it's easy for me to track the position of my files and what I'm needed to be what I need them to be done. That has helped me very much in terms of completion, because I'm able to tell what files have not been actioned. And as we speak, it has really helped me so that once I've allocated the duties in terms of fixing, some of them taking mention dates, some of them informing clients of the hearing, it has helped me finalize the cases at a very, and also teamwork has helped me through coordination.
Okay, thank you.
Yes.
Asante.
Thank you, Honorable Chair. Wakili, please tell us what is the responsibility of a judge in relation to social media activities?
Sorry. The relationship of a judge with social media activities, in terms of work, I've seen it's about sensitization to the public of what the judiciary is doing. And through social media, people have learned about the judiciary, what they've been doing in terms of performance, in terms of delivering access to justice to the people, in terms of...
I'm asking about you as a judge. When you become a judge,
yes,
if you're successful,
yes,
what will be your responsibility?
Through the social media.
Yeah, in regards to social media.
Myself accessing it?
Yes.
Of course,
as a judge,
I'll have to be careful on what I post in the media, because my conduct out there, everyone looks at your conduct. I have to ensure whatever I'm posting, I have to be sensitive to what I'm posting because of the public.
What happens if you post something and there is a negative comment or unpleasant comments, because this is social media and everybody can say whatever they want to say?
Because under the code of conduct, we are not allowed. We are not allowed to post things that can go into your conduct.
Please expound.
Things that will expose you to the public, depending on what you are posting.
Yeah, but you've just said that you use it to communicate to the public and sensitize. Is that the work of a judge?
I'm saying if I was thinking maybe you're asking about the methods judges can use to sensitize the public, but I've understood what
do they go to that depth themselves as judges?
No.
Okay.
It is the judiciary through the media.
Okay. Now, Wakili, you're said to be very active on social media. What would you say about that? And how are you going to make this transition if you're successful?
Okay. I can't even remember the last time I was in social media, but I post once in a while, and whatever I post, it's not something that the public can complain. It's something just social or something not negative.
Okay.
Or something anyone can worry about.
Okay. Now, how would you react to critics who feel that you are self-centered and maybe not considerate of other people around you as long as things go your way?
Maybe they're wrong. I can say they're wrong. Because I'm somebody, when I learn something, I would want everyone to know. I'm not somebody I keep anything to myself. I learn anything new, even in terms of practicing family law, the way I've been practicing. My colleagues have been seeking precedents. I give them. I'm never self-centered myself.
This is in terms of when you have an interest in a matter. You will only think of your side and not the other people around you. I'm asking that question in that context.
Okay. Okay. Usually, the way we do matters, or the way I do matters, you can sense whether the other side is willing to settle or not. If it's not willing to settle, then usually I proceed. But I can't insist on negotiating when there's no room for negotiating. If there's room, I usually negotiate, and I also initiate. If there's no room, then I cannot be that self-centered. I just have to proceed with my client's instructions.
Okay.
Yes.
Thank you and all the best.
Thank you.
Thank you very much, Commissioners, and also Madam Machio. I think this brings us to the end of the interview, but we always give a candidate an opportunity to also engage the panel. If you have any question.
I don't have any question. The only thing I would want to I think I've never appeared in a panel. I sounded, maybe I was scared, but I apologize for that, and I thank you for giving me an opportunity. I know there were many applicants. I thank you for giving me an opportunity to appear before you.
Okay. It's always a running curve.
Yes.
When you get opportunities to do things you have never done.
Yes.
Yes, but on behalf of the commissioners, I wish you well.
Thank you.
We will get in touch with you when we complete the exercise. But for now, we encourage you to continue impacting the society positively, especially by representing the vulnerable groups of our society, the women and children, defending human rights.
Thank you.
We wish you well.
Thank you.
And wish you a good day.
Thank you.
Yeah.